May I invite Ms. N. Krishnaveni, Senior Advocate, Chairperson of the LexiCon, to come over to the dais. Now I request the guest speaker, Dr. V.S. Elizabeth, Vice Chancellor, Tamil Nadu National Law University, Trichy, to be escorted to the dais. Now I would like to request Librarian of MMBA, Mr. K. Prabhu, to honor the guest speaker with the memento as a token of gratitude. Now I would like to request Mr. K. Praveen Kumar to adorn the guest speaker with the traditional shawl. Thank you, ma'am. Thank you, sir. On behalf of MMBA, I would like to share a few words about the guest speaker. Dr. V.S. Elizabeth is the Vice Chancellor of Tamil Nadu National Law University, Trichy. She was a part of Gender and Law Association Forum in American University, as well as a charter member of International Association of Law School. She visited many countries for research work related to women and their domestic violence. She was a part of the team in framing curriculum for teaching feminist jurisprudence in the law colleges and law universities of the country. She was appointed as a member of the high-level committee on status of women by the government of India. She is passionate towards teaching and about history and rights of women to live with the dignity. Such a renowned person is here to let know us about feministic legal methods for more collaborative decision making.
Feminist, this is not a man and a woman issue. It's about the people and prejudice. Men should be glad that women just want equality and not revenge. How to come to a decision using legal methods is her specialty. Let's hear it from the expert who has done a wide research on the gender justice and also would like to hear from her the worldwide practice of this subject. May we please have Professor, Vice Chancellor, Dr. V.S. Elizabeth to enumerate on the topic use of feminist legal methods for more collaborative decision making.
Thank you very much for the introduction. I must also thank Mr. Srinivasa Raghavan for having invited me to share my thoughts at this symposium filled with such eminent persons as our judge from the Supreme Court, Honorable Justice Mr. Rama Subramaniam, as well as all the other judges, honorable judges of the Madras High Court, as well as the former judges of the Bombay High Court, professors, other advocates, lawyers, and students from the different colleges here in this afternoon. I know it's already lunchtime, but I will not talk for more than half an hour, and just bear with me. This is another topic, a new topic. Most, if not all, lawyers and judges are very uncomfortable with the ideas of feminism, feminist legal methods. As Ms. Krishnaveni mentioned at the beginning of this program today, because we don't understand feminism, we often are so skeptical and even hostile to feminism. But I hope that having heard a lot of new topics in the course of this morning, you will be open to at least listen to what I have to share and look at the possibilities, because we've had topics this morning which all feed into what I'm going to say right now, from what Justice Sumant said this morning about mediation. It is in a sense leading up to the topic that I am discussing today about collaborative decision making. So you can see bits and pieces of different things that have been discussed in the course of this morning in the presentation that I'm going to make. And I'm using a PPT because I think the points that I want to share will be more clearly imprinted on your minds if you can see it rather than just hearing it, in case you don't hear me very well. Okay. I wanted to start with what is feminism, for the simple reason that we have a lot of misconceptions about feminism, because oftentimes the university through which we get our knowledge about anything is the WhatsApp university, and the WhatsApp university is absolutely nonsense. So when we read everything through WhatsApp, then we are completely misinformed, and as a consequence we have a dislike of many of the things that are useful and good for us. So what is feminism? Can we just go back? I haven't even discussed it. Be a little slow. Yeah, thank you. So first of all, feminism isn't simply something that, I feel, or I think, or I imagine. Feminism is a very academic endeavor. It is an interdisciplinary approach to issues of equality and equity. So at the heart of feminism are the issues of equality and equity, which are at the heart of the legal system that we're all a part of. And what is this about? It is an interdisciplinary approach, which means that it is not just law, but it is all the other disciplines put together, whether it is history, economics, political science, law, as well as, of course, the science, disciplines from the science and the humanities. We draw from all these disciplines, the tools of analysis they use, the methodologies that they employ in order to carry out their own understandings in their respective disciplines. So it is an interdisciplinary approach aimed towards achieving equality and equity, and it is based on gender, gender expression, gender identity, sex and sexuality, all of these through the social theories. So it is not just some irrational emotional response to the oppression, the subordination, the discrimination and exploitation of women. It is actually built on the research and studies of scholars from all the disciplines, and that is giving you the perspective to understand the world we live in, right? Now, feminism is both an intellectual commitment and it is a political movement which seeks justice for women and the end of sexism in all forms, which is why you can't separate it from who you are, which is also the reason why they say that the personal is political. It is drawn from one's own personal experiences. So if I'm passionate about what I'm talking, it comes from the fact of me being a female for the last 62 years. So my experiences from the time that I was a little girl to now an old woman is what informs my decision making as well as, who I am. Now, coming closer to, what we are all involved in, jurisprudence. And jurisprudence is not neutral, it is not objective. There are different political thinking that goes into various schools of jurisprudence that all of us have studied. Most often, of course, in our country, we study purely from the liberal perspective. But there is the critical legal studies, there's the critical race theory, all of these also there. And along with them is feminist jurisprudence. Catherine MacKinnon is a professor of law in the University of Michigan, and she was the one who coined that phrase, sexual harassment. If it wasn't for her coining that phrase, there would not be the kind of understanding we have today about sexual harassment, the problem with it, and how do we provide legal remedies for it. So Catherine MacKinnon defines feminist jurisprudence as an examination of the relationship between law and society from the point of view of all women. And here, there is not homogenizing women. Obviously, women come from different sections of society. Caste, class, sexuality, as well as, of course, all the other things which go to make who we are as individual human beings. And therefore, she says it is about looking at a life situation from the point of view of all women, which means defining a situation shared by all women and including in the experiential data about that situation the experiences of women as they differ by age, race, class, religion, and sexual preference. Feminist jurisprudence must include the intertwined and layered specificity of women's lives at every stage of inquiry in order to be accurate. Lastly, feminist jurisprudence inevitably raises questions about the methods of jurisprudential inquiry and how these have been or are gender biased, right? Because we assume that the law is neutral and objective. It isn't. The law is patriarchal. It's very interesting, as I think more and more about the discipline of law. We represent justice as a woman with a blindfold. But law and the legal system are completely male, patriarchal. They look at women and women's issues just as men look at women and women's issues. Catherine MacKinnon says this in her book, Towards a Feminist Legal Theory. And I can, having read and been teaching for the last 39 years of my life, I can tell you that this is completely, affirmed by my study of the judgments, the decision making, the kind of legislations we have enacted. All of them tell us how much it is male biased. Now, what is the relationship between law and society? Law is built on a worldview that presupposes that patriarchy is normal. We just take it for granted that the differences between men and women are natural and inherent, rather than something which has been produced by society very consciously, deliberately, in order to maintain male dominance in every sphere. And because we do that, law and the entire legal system are based on the presumption that men and women are not equal and that women are subordinate to men, and this means that law is not neutral. It supports a particular traditional way of life that is unjust. Now, while of course we do have the Constitution which says women and men are equal, and the human rights conventions talk about equality between women and men, when we look at the way in which we interpret the law, and I like what the person who last summed up, Justice Dama's talk said, the fact that law is interpretation. And that is at the heart of it all. First of all, law is put together by human beings. And who are the human beings who are in our legislatures? I mean, leave alone our courts. It's largely men. Men from a particular caste, particular class, even possibly from a particular region, despite the fact that we have seats distributed all over the country. So they are making laws based upon their particular interests, what concerns them, what affects them, and what they want protected. Let's take the simple, there are two examples I can take which reflect this very clearly in terms of lawmaking. Right? One is the marital rape issue, which will be discussed later. Why is it Parliament has been so reluctant to recognize that marital rape is rape? It's a crime. Rape is not consensual sex. Rape is crime. Why have we been so reluctant to do that? Just think about it. Second thing, reservation for women in Parliament. The first time a bill was tabled was way back in the 1980s. The man who opposed this is no more Mr. Sharad Pawar. But I don't think that's going to make any difference if the bill is tabled again in Parliament. Why has this bill also been opposed? On the one hand, we say reservation makes no difference, nobody's lives are changed, etc. On the other hand, we have opposed this bill. What is the reason for it? I can look at, the composition of our Parliament, etc., and then we understand where this comes from. Right? So which is why I said that law is biased. Okay. The relationship between feminist jurisprudence and the law. Feminist jurisprudence raises questions about the methods of jurisprudential inquiry and how these have been and or are gender biased. It looks at law in its entirety in terms of the legislations, the interpretations, the decision making, the legal system, the judicial setup, looks at all of it. And through feminist jurisprudential inquiry, it is clear that the law and the legal system are gender biased. Seeing, describing, and analyzing the harms of patriarchal law and the legal systems is a part of feminist jurisprudential inquiry. In other words, look at what has been the impact of law which has been so gender biased. The most recent debate is about, allowing people of the same sex to marry. Now, I may have my own personal opinions on it, but as a judge, as a legislator, what should govern my thinking and my interpretation? The constitutional values. We do not have to be homosexuals in order to be supporting same-sex marriage. We may have completely opposite views based on our religious beliefs, our cultural differences. But the question is, what should govern the position we take as judges and as legislators? And that is where we find that when we use the feminist jurisprudential inquiry of the law, we find that it is gender biased. And here I'm not talking just about women, I'm talking about the entire gender spectrum. Because that's another thing, right? The law is so uncomfortable with anything that is not a binary, yes or no. And it is actually so funny when we start looking at everything in that yes or no terms. Black and white. Nothing is black and white. Everything has a large gray area. And that gray area informs the decisions we make. Nothing is absolutely rational or absolutely emotional. Every reason is informed by some emotion. Every emotional response is informed by reason. Until we understand this, it will be difficult for us to really do justice to all those people who don't think in black and white terms. And that is why so many people are unhappy and discontented with the justice that is dispensed. Thirdly, no, please go back. The third point on the relationship between feminist jurisprudence and the law is that feminist jurisprudence inquires not only into the harms of patriarchal law, what has it done, but also into the possibility and characteristics of a world without patriarchal law and of a non-patriarchal legal system. Can you really imagine a world where the law is not informed by male dominance or in the production and preservation of male dominance? Can we imagine a world like that? Feminist jurists are doing just about that. So not only are they studying the harms contributed by patriarchal law and legal system, but they're also seeing the possibilities of a world without such patriarchal bias in the law and the legal system. Now, all of us know the importance of legal methods, because the way in which as lawyers, and of course as law students, law teachers, and the judges, we go about our work is by the use of legal methods, right? And they are important because one, they determine the sources. What will you consider as facts? Because we are always choosing relevant facts, put aside the irrelevant facts. How do we decide what are relevant facts? What makes us think that some facts are irrelevant for this particular case? It is informed by the legal methods that we are using. And the tools of analysis we use, once we have decided on the relevant facts, what are the tools of analysis we use? What are the questions we ask? Feminist legal methods are about a new set of questions that people have not thought of. And it is that, which I want to take us into in a little while. Legal methods enable us to decide questions of relevance, which questions count, what evidence supports answers, questions of structure, like what is concerned with what and how, as well as questions of reliability, like when is information worthy of belief? Like we say, hearsay evidence is inadmissible. How do we arrive at that? When did we arrive at that? Right? So those are the kind of things that we go through when we are using legal methods. Now, feminist legal methods are grounded in women's experiences of exclusion. We are not part of any discussion. We have not been asked what is it we want. So, oftentimes there's so much of opposition to any new legislation that is enacted to protect women's rights. But the fact is, none of these legislations have made my life better in these last 62 years. From the time I was, a little girl to who I am right now, I don't see the world any different. Right now, my life is very comfortable because I have my own office car. And I have a driver much younger than I am, who I know through having interacted, I will not be subject to any kind of sexual harassment. That he will not be looking at my face in the mirror, he will not be looking at my body when I walk. I have that confidence. But the moment I go back to National Law School as a professor and I have to travel by public transport, every time I step out of my house and start walking, I have to be wary, I have to put on this extra consciousness about everyone on the road. I have to look right, left, and center. When I sit in the bus, I have to see who is going to come and sit next to me. Even when I travel by plane, who is sitting next to me? So I had to worry about that when I was a little girl, and the guy who used to work in my father's cycle shop used to take me on the cycle to school. He used to sing all kinds of songs to me when I was barely 8 years old. I didn't understand them. That's one of my earliest memories of sexual harassment. Because again, problematically, these memories don't go away because they're all traumatic experiences. They're experiences that are unwanted. I didn't want to hear some film song being sung any more than I want a man sitting next to me on a plane put his hand on my armrest or touch any part of my body and assume when I stay quiet that I like it. Right? So these are things that are important for us to understand that, feminist legal methods, feminist jurisprudence comes from women's experiences of being excluded. That decision on custody, that decision on divorce, that decision in the rape case, that, releasing of convicts who commit, heinous crimes against women. These are all experiences of women's exclusion. And these methods, the feminist legal methods, are both critical and constructive. So it is not like they deconstruct and leave it there all broken up. They also tell you how you can construct a new thing, a new structure, which will be more inclusive of all peoples. That's again the beauty of feminist legal methods. It's not just about women. It's about all excluded people. You can just substitute women with Dalit, with Muslim, with the poor, and you will get the same answers. Right? So the feminist legal methods help to reveal features of legal issues that more traditional methods tend to overlook or suppress. Traditional legal methods place a lot of emphasis on predictability, certainty, and fixity of rules, a point that Justice Sumant was referring to in her talk, because of which it is so difficult to settle matters in the court, where you have certain law, you have certainty about procedure, and because of that you decide right or wrong, black and white. Whereas through mediation, arbitration, you're able to go past those fixity of rules and certainty of the law. And that is what feminist legal methods contributes to. It values rule flexibility and the ability to identify missing points of view. Right? Something is not right here. How do we understand what is wrong? The way in which we are dealing with sexual offenses against children today comes from an understanding of that. Because if you remember, I am a feminist legal theorist because I read many judgments which horrified me. And one of those judgments were about this, and again, I'm not good at remembering case names, but you might be able to put two and two together, was a case of an 8-year-old child, the daughter of a bureaucrat in Delhi, who had been sexually abused by her father and his friends. Now, when this child was questioned in court about what happened to her, she couldn't speak the language of the law, nor of biology. Because at 8 years, she hadn't discovered there's something called a penis. So when the judge asked her what happened, she said something like a bottle was inserted into her private parts. Can you imagine ruling on something like that and saying, no evidence of penile penetration, and therefore it was not sexual assault or rape? The father was acquitted. And the entire thing was, said to have been the mother's connivance in order to get back at the father because of some marital dispute. That's one of the first cases that I read. Today, when you look at the Protection of Children from Sexual Offences Act and how the courts are dealing with it, we have judges who are really sensitive and understand that the child doesn't speak the language of the adult, that the child's experiences are far different from the experiences of the adult. And so we have actually, have closed room meeting, while of course the accused, can hear. The child doesn't have to see the person who subjected her or him to such trauma. Right? We moved a long way from that. From the idea that, we need to be just focused upon the certainty of rules and the, even uniformity of legislations, etc. So what are these feminist legal methods? There are 3 of them which more or less inform all feminist legal research. First is asking the woman question. So this is not going to every woman and asking her a question. Asking the woman question means identifying and challenging those elements of existing legal doctrines that leave out or disadvantage women and members of other marginalized groups. So we're seeing whether these legal doctrines are including women and other marginalized groups, or are they excluding them and their experiences from, the framework of the law? The second method is feminist practical reasoning. It is reasoning from the position of finding pragmatic legal solutions to concrete dilemmas, rather than static choices of either or and often mismatched perspectives. And the simple example I will use for that would be, in criminal law we have this exception of sudden and grave provocation. Because the assumption of law is that man is rational, when the reality is no human being is completely rational. But because we have this abstract human being who is supposed to be rational, we say the rational man will not suddenly, kill anybody. It's only the irrational man who's doing that. But the rational man may lose his reason under sudden and grave provocation. Now the reality is, because of how women are socialized, women do not do any sudden and grave provocation reactions. Women's responses come from their practical experience that if I have to hit him back when he is sober, he will beat me up more. Therefore, like in that case which took place in England, R versus Ahluwalia, which was, filmed as Provoked with Aishwarya Rai playing the leading role, she waited. She had been subjected to cigarette burns for a long time. She wanted him to experience what it felt like when you're burnt. So she waited till he went to sleep, and when he was asleep, she poured a little bit of petrol on his toe and decided to strike a match, because she did not know that that would result in, petrol will become gas and then the whole bed could catch fire. But that is what happened, and he died. Now, because it wasn't sudden or grave provocation that led to it, she was convicted of murder. In fact, it seemed like cold-blooded murder because she planned it. It isn't like suddenly in the moment she did it. It is only after women's groups seeing the pattern in other women who had done similar crimes that you came up with the exception battered woman syndrome. The fact that women who are subjected to domestic violence on a continuous, regular basis believe that they can't take care of themselves and defend themselves when they are being beaten up, and on the other hand, tolerate that beating, that violation, that abuse for years together sometimes, and then comes a breaking point when they fear either that they are going to be killed or that there is danger to their children. Now that tells you that how women and men respond in society depends on their experiences, and there is no black and white. And the law doesn't capture the experience of everyone, because most of law is abstract. We even teach it like that, right? When A beat up B, then B went to C. We are so hesitant to put names to those, even fictitious names. Whereas when we do that, we make it more real. And it will actually remember those things. That is what feminist practical reasoning is about. Pragmatic view of the law and the experiences of women, rather than looking at legal solutions from static choices of either or and often mismatched perspectives. Third method is consciousness raising, and that is what I want us to kind of dwell on, because that consciousness raising is the method that can move towards and contribute towards collaborative decision making. What is consciousness raising? This is not about raising the consciousness of women to let them know that they're being subjected to injustice. Women do know. All of us are aware that what's happening to us is unfair, but we think we are helpless. We can't do anything, so we just tolerate it and live with it. Right? Consciousness raising, can you please go back? Consciousness raising is seeking insights and enhanced perspectives through collaborative or interactive engagements with others based upon personal experience and narrative. So the way consciousness raising became a method for feminists came from practical experience. Because from the earliest responses of feminists to domestic violence was providing shelters for women who were thrown out of their marital homes or had to flee their marital homes because of the risk to their lives. So shelter homes were created where they could stay for a few days and then either go back to their marital homes or possibly find a new future. And oftentimes women who are subjected to domestic violence, every one of them thinks they made a mistake. The fault is theirs. So there is self-blaming. I should have been more careful. I should have cooked properly. I shouldn't have gone to my mother's house without taking his permission. I should have dressed up quickly and come down when he wanted to go out. I should have taken care of the children. I shouldn't have burnt the food. I shouldn't have gone to the next door. I shouldn't have gone out with my friends. You know, numerous things that women think they did wrong and therefore this happened. I should have been more attractive. I should be, you know, more intelligent so that I can have an intelligent conversation with him, etc., etc. But when they came to these shelter homes, they realized that they shared similarity of experiences because there is a pattern to domestic violence. And what happens not because women have done wrong, but because of the nature of society which is patriarchal. You know, because it isn't as if a wife can't raise her hand and beat her husband. It's not as if every man is physically much bigger than the woman he marries. But a wife will not dare to raise her hands because of socialization, where one is taught to respect one's husband. One, the man is older often, maybe more educated, maybe from a better class or strata of society, and therefore she restrains herself because that's what she's been told is right. But the man never stops to think, you know, you talk back, fat. You went out without my permission, how dare you? Right, this is just, it's like, you know, a man will not think twice about slapping his wife, whereas a wife will think 100 times before. I don't know of any wife who hits back. I mean, actually, there are maybe a few. So let me not also, again, make this a fictitious thing. Now, in that context, as I began to share this, they realized, it is, even if I cooked right, I still was to blame. If I dressed up, I was to blame. If I didn't dress up, I was to blame. If I took permission, I was to blame. If I went without permission, I was to blame. Anything related. So they realized that there is a pattern to it. They also realize that it is cyclical, because very often a man will slap his wife or beat her up, scold her, abuse her emotionally, verbally, and then, you know, come and say, I'm so sorry, I was very stressed out at the office. You know, bring her flowers, bring her, you know, a sari, take her out to a movie or something like it. 2-3 months later, same thing will happen at a slightly escalated rate. And this happens in every strata of society. You just have to read this book, My Feudal Lord, by a woman from Pakistan who belongs to the very elite group in Pakistan. And you will see the similarity between her life and a woman who lives in the slum here in India. It is then they realized that this is not them individually, but it is a social structure that is responsible. And that then enabled them to overcome what they had gone through, the self-blaming, gaining confidence, and being ready to live a life outside of marriage. Think about a future without, you know, the present husband, if he's unwilling to go for counseling and change his ways and stop the violence. Because let me tell you, most women who report domestic violence are not seeking divorce. They're not seeking incarceration of their husbands in jail. In fact, most of the 498A cases are not from women who are subjected to domestic violence. They're often women who are caught up in divorce proceedings where the man is unwilling to grant them divorce or custody. And then the lawyer, which all of you must know, will say, slap 498A on him. Then he'll immediately come to the discussion place, right? So consciousness raising is about understanding what is a reason for the kind of things that come up before us through hearing the different people in the court and by discussing it together so that we actually understand better what has happened. So why in this context should we use feminist legal methods? One, because legal methods generally, which are male in nature, used to treat women and other marginalized groups as outsiders and therefore excluding them from the practice of law or forcing them to conform to the dominant male view and end up experiencing injustice. Also, there is a need for ways of challenging and undermining dominant legal conventions and developing alternative conventions which take better account of women's experiences and needs. Therefore, using feminist legal methods will ensure that we're doing a more inclusive practice than what we have been doing till now. Now, the first of these, as I told you, asking the woman question, so what is it really as a method, It's merely asking a group of questions known as the woman question, and it is nothing but asking what are the gender implications of rules and practices that appear to be gender neutral or objective otherwise. How will this rule, this law, impact women? And again, I'll just take an example. I'm a professor of history at the National Law School, and therefore, I will take an example from history. All of us are familiar with the Hindu Widow Remarriage Act. And all of us hail it as one of those laws which supposedly empowered women. On the contrary, it took away the powers that women already enjoyed in society. Because the only widows who were not allowed to marry were Brahmin widows. Dalit, Shudra women who were widows not only remarried as a part of customary practice, but also inherited the property of the deceased husband, which was part and parcel of how their lives went on. But with the enactment of the Hindu Widow Remarriage Act in 1856, the only cases that went to the high courts of Allahabad, Calcutta, Bombay and Madras were from the men of these communities, the Shudra and Dalit communities, saying the Hindu Widow Remarriage, Section 4 says, when a widow remarries, she will forfeit the property of her deceased husband. No Brahmin widow went to court and said, the law empowers me to remarry. I have a right to remarry now under the law, but my family is preventing it. There are no cases like that. All the cases were from the men going to the court and saying, we want these women now to give up the property that customary law had permitted them to retain. Only the Allahabad High Court upheld customary law, customary right, whereas Madras, Bombay and Calcutta upheld the legislation and said Section 4 says you have to give up, then you have to give up. So then you tell me which widow will remarry. Do you give up property in order to remarry? Because what is remarriage bringing you? Whereas property, on the other hand, gave them some amount of independence and the ability to, run their lives. Right? So the woman question is essentially looking at those gender implications. Here are some questions that are asked in the context of the woman question. Have women been left out of consideration? Can we just go back? If women have been left out of consideration, how? How can that omission be corrected? What difference would it make if we corrected this omission? How the law fails to take into account the experiences and values that seem to be more typical of women than men? How existing legal standards and concepts disadvantage women? These are just examples of a few questions you can ask when you use the feminist legal method. Feminist practical reasoning builds upon practical, that is the focus. What is the real life experience of women? Like, in the cases of, say, custody or in sexual assault, we build an abstract image of a woman and a mother. And we expect woman and mother to act in that fashion. When they don't, then we say it is unnatural and we get biased against such women. One example, if a woman is sexually assaulted, we assume she'll be screaming. She'll scream for help. The reality is you get paralyzed with fear. So no sound will come from your mouth even if you wish to yell for help. But because you didn't scream, you didn't fight back, your entire experience of sexual assault can be reduced to consensual sex. So abstract expectation is not reality. The practical reality is how one does behave in a real life circumstance. Custody battles again, right? We expect a woman will want to have custody of her child, that she would have been very maternal, etc. Maternal instinct is a theory. It is not as if every woman has maternal instinct. That is why when postpartum depression sets in, and these women kill their babies, the court is shocked. How can a mother kill her own baby? But do you know something like postpartum depression actually exists? That many women go through it, and for a long time there was no remedy, nobody understood it. Only recently we've begun to understand and therefore provide the help that these women need. Right? So that is what we mean by practical, feminist practical reasoning. It is located in women's real life experiences. Right? So it is committed to the notion that there is not one, but many overlapping communities to which one might look for reason. They argue that no one community is legitimately privileged to speak for any other. Now, consciousness raising is about expanding perceptions. through the sharing of experiences, our understanding greatly improves of situations and things that happen in each other's lives. Many people don't even know this is the experience of women or many of the marginalized groups, what they go through with the kind of things that are done to them as a context of socialization and the social structures in which we live. Consciousness raising through this personal sharing helps expand our perceptions, and consciousness raising is an interactive and collaborative process. It's about articulating one's experiences, and it's making meaning of the experiences with others who also articulate their experiences. Judith Resnick, a feminist legal scholar, says that this method would lead to more collaborative decision-making among judges, and that such changes suggest possibilities of collective engagement rather than the individual exercise of judgment and power. That brings me to an article I read recently, written by the current Vice Chancellor of the National Law University, Delhi, Professor Bajpai. In this article, is judicial majoritarianism justified in the Hindu on February 1st, 2023. He wrote this immediately after that decision on demonetization. As you know, Justice Nagaratna's decision was the lone dissenting judgment. So in that, he raises these questions. His first question is, we should challenge the weightage given to numerical majorities in judicial decisions by our constitutional courts as opposed to the merits in their reasoning. Why? Because he says all the judges on a particular bench give their rulings on the same set of facts, laws, arguments, and written submissions. Same thing is laid before all of them. In the light of the same, any differences in judicial decisions can be attributed to difference either in the methodology that is being employed by each judge and the logic applied by the judges in their interpretation. So facts, circumstances, law are all the same. Difference therefore arises from either difference in method or difference in the tools of analysis one is using, right? And Jerome Frank, talking about this, says that the judges are working on their own judicial hunches, which may be an outcome of their subjective experiences, outlook, perceptions, prejudices, and biases. In such circumstances, it is entirely possible that the majority may fall into either methodological fallacies and errors or be limited by their judicial hunch respectively. Therefore, I think that it is only but right, and as Professor Bajpai says, a meritorious minority decision, irrespective of the impeccability of its reasoning, receives little weightage in terms of its outcome. Our constitutional history is replete with such meritorious dissents, and he gives us the names of 3 cases. The Justice Khanna's opinion in Jabalpur versus Shukla, 1976, where he upheld the right to life and personal liberty. And then you have another example in the dissenting opinion of Justice Subbarao in the Karak Singh versus State of UP in 1962, where he upheld the right to privacy, which today has received the judicial stamp of approval in Pitosami and others. Right? So given this background, what is the way forward? More collaborative decision making among judges, rather than a majority opinion and a dissenting opinion. Possibilities of collective engagement rather than the individual experience of judgment and power. Consciousness raising as a method values risk-taking and vulnerability over caution and detachment. Honesty is valued above consistency, teamwork over self-sufficiency, and personal narrative over abstract analysis. And therefore, I'm saying when we use feminist legal methods, we might be able to deal with the kind of positions we land up in a majoritarian decision-making situation as we currently have. And as Professor Bajpai argues in that article, there is no place for a majority-minority view in judicial decision-making. That's okay in the parliament. But when we're dealing with the administration of justice, it'll have to be more collaborative, more consensual, which is the reason why we're moving so much towards mediation, arbitration, negotiation, right? So in that context, I'm just placing a possibility that resorting to feminist legal methods, particularly consciousness raising, may actually lead to more collaborative decision making. That's it. I don't think I'll go beyond that. It's already almost 2. Thank you very much.
Thank you, Madam Vice Chancellor, for waking up the woman in me, but for it, people still think that I only defend men. May I now request Mr. Mehboob Atif to give his understanding on this lecture.
Good afternoon, Professor and honorable judges, my colleagues in the bar. I could say it was an electrifying performance by Professor as usual. But the core of what she was trying to convey is our justicing system depends on our norms, our perspectives, our consciousness. And that is patriarchal. I mean, we are not even conscious that it is patriarchal. And we tend to base our judgments on the basis of those understanding. Now, I can just give you a small example to substantiate that, how unconsciously we are adopting that. When there was the earlier session, when Justice Anita Sumant was introduced by one of the panelists, she was saying that her ladyship was part of the all-woman full bench. And I was just thinking to myself, why did we feel it so special? Because for us, we thought the work of dispensing justice was a duty of a man, that is subconsciously in our mind. And therefore, when there is a full bench of women judges, we find it special. Now, this immediately kindled me a famous quote by Justice Ruth, when it was asked to her, and I'll read out that. I am sometimes asked, when will there be enough? And my answer is, when there will be 9. Now, 9 is because the US Supreme Court has only 9 judges. People are shocked. But it has to be seen that when all 9 judges were men, nobody raised a question about that. So exactly that is what is here. We find it special because we subconsciously think so. And why does subconscious mind is important is because sometime before we had a lecture by Justice Anand Venkatesh, where he said all our decisions, all our thinking, all our norms, all our morals, everything depends on what we think subconsciously. This is also founded in our very historical understanding because it said yata bhava tata pratha. What you think is what you are. And therefore, I think Professor was trying to only import that. And another part is, why is collaborative justicing important? Because 48% of our population is women, but in any law, the standard fixed is of that of a man of ordinary prudence, civil law, a man of average intelligence. What is reasonable restriction is tested in light of the touchstone of a man. Fundamental freedoms tested in light of a man. I have a small anecdote to share here because Krishnaveni madam is also here. When I joined in the bar, one of the first few months there, Justice Hari Parandaman was presiding, and there was an interesting case where a married daughter who after marriage, when she was returning back to her husband's home, they met with an accident. The husband and the wife both died. While when they claimed motor accident compensation, the tribunal said that the parents of the boy were entitled to compensation while the parents of the bride were not entitled to compensation because they were no longer dependent on her. So Justice Hari Parandaman was shocked by this, and Madam Senior Counsel Krishnaveni Madam assisted in that matter as amicus, and the court ruled that this is inherently discriminatory. So I can really reflect with what Professor said, that our foundational understanding happens to be on the basis of a man's perspective, and unless we change that, we will not have better justicing. And why is it important? Because it's not important that only male judges have, I mean, female judges will carry out a feminist approach. Not at all. Because there are many high courts in our country, at least there are 7 high courts where there is not even a single woman judge. And there are some judges, I mean, at the same time you can also see in the US Supreme Court, there was a recently appointed judge, Amy Barrett, and everybody feared, and in fact after her induction was when Roe versus Wade was overruled. So therefore it is our gender sensitivity or consciousness, whether it's a male judge or a female judge, which will help in collaborative decision making. And lastly, I would like to quote with another quote of Justice Ruth Bader Ginsburg, where she said, and I think I fully agree with that, "I ask no favor for my sex. All I ask of our brethren is that they take off their feet out of our necks." And I think if we do that, we will have real, real justice, in the sense we will be serving justice to everybody, for it's justice for all. Thank you.
Thank you, Mr. Artist. All the women present in this hall would like to wholeheartedly thank you for your understanding and appreciating women. Thank you once again.